Hey everyone, in History of the United States Constitution, I'm going to put up a fairly brief video or discussion of the 14th Amendment to the United States Constitution. It's not to suggest that the other amendments aren't significant, but we just finished up talking about the Bill of Rights, Amendments 1 through 10, and we only have so much time left in the semester, and the 14th Amendment is really almost, in a sense, I think, the sort of cornerstone of constitutional application in our nation in order for us to live up to those noble words that we think of in the Declaration of Independence, that all people, although it said men, but we like to think of it broader than that. We like to think that all people are created equal and we all should have equal access to justice. And other terminology, and I can't say it nearly as eloquently as Thomas Jefferson did in the other co-authors of the Declaration of Independence, but we know the 14th Amendment finally brings those aspirational goals of an equitable society to fruition. And it comes about as a result of the end of the Civil War. I'm going to mention briefly the 11th Amendment. There were some concerns about states, individual state governments being sued by individuals from other states, really opening up this can of worms where the federal authority will suddenly be able to create judgments against states, and that would influence federalism. And states are saying, whoa, this is going way too far in terms of giving up our sovereignty. State sovereignty should mean states decide when and under what circumstances we should be able to be sued. And there was some case law that came down that allowed a citizen of one state to sue the state of another, and that was considered to be a horror show. So the 11th Amendment banned that. States can still allow themselves to be sued. Most states have what we call a Torts Claim Act, where there's provisions about how much you can sue for and under what circumstances a citizen of its own state or other states may or may not sue. But the 11th Amendment did away with the recognition that a citizen of one state could sue another state. We wanted to ban that because it was going to open up a whole can of worms. I say we, I mean the nation wanted to ban it. 12th Amendment is to clean up that mess of the election of 1800. The Electoral College had made clear when you cast your vote, is it going to be for vice president or president? And we needed to clean it up. We didn't want another Thomas Jefferson, Aaron Burr situation. So now the ballots are clear which candidate gets a vote for president, which candidate gets a vote for vice president. So there won't be any mix up on that. But then the 13th Amendment, now we get into the Civil Rights Amendment. 13th Amendment, in many respects, I think is embodied in the 14th. And that's why I'm going to spend the next assignment focusing on the 14th Amendment. But the 13th Amendment was a recognition that a lot of people think the Emancipation Proclamation freed the slaves. That's not true. The Emancipation Proclamation was an executive order by President Lincoln freeing the slaves in those states that were in rebellion. You have to remember that a few of the states were not in rebellion that were slave states, and there were other states that weren't deemed traditional slave states that had slaves in them, states like New Jersey, for example. And so it didn't free all the slaves. And if it did free the slaves, there was a real question about the legality of that in the long term, because it was used as an act of war, meaning to benefit the Northern interest in the war, to preserve the Union. Slaves would be free to undermine basically the Southern power in the conflict. And so Lincoln, being the brilliant man that he really was, recognized in order to really bring an end to slavery, there needed to be an amendment to the United States Constitution, basically outlawing it, because in many respects, other parts of the Constitution had historically, like the Fugitive Slave Act was embodied in the Constitution in parts, a recognition that slaves would be counted as 3/5 a person for purposes of apportionment of representatives in the House of Representatives. So there needed to be an amendment to correct it. And if you ever watch a movie, when I saw it when it first came out, I don't know, it was like 10 years ago, it came out, movie Lincoln with Daniel Day-Lewis. He got the Oscar for Best Performance. I remember going to see it. When I went to see it, it was opening night, like in a movie theater in my local town, and I was the youngest person in the movie theater. I kid you not. There's a lot of oxygen tanks, a lot of elderly people in there. It made me feel good because I'm starting to feel my age, or I certainly was starting to feel it 10 years ago. I guess it was kind of an old person's movie, but it was done so well. And it really did focus, I think, in many respects, not on just Lincoln or the Civil War, but it focused on the passage of the 13th Amendment to the United States Constitution, the legality of it. In order to end the institution of slavery, there had to be a constitutional amendment. And if the Union came back into the fold, meaning the southern states came back into the fold, we became one nation, the likelihood of passing the 13th Amendment would have been very much jeopardized, and Lincoln needed to get it passed before that occurred. Fascinating set of circumstances. And I think I'm going to put the movie clip up there about that one scene where he's really demanding of his leadership team to get this 13th Amendment passed immediately, because if we don't, we risk really being able to outlaw on a national level through the supreme law of the land, the United States Constitution, the 13th Amendment. But the 14th Amendment's where it's at. But I'm going to jump to the 15th for a second. So 13th Amendment ends slavery and any form of indentured servitude as well, because otherwise there would be people that would be put into debt. Often people of color would be put in situations of grave debt, and then in order to pay off the debt, civilly, arguably, you could be forced to work off that debt. That's actually illegal under the Constitution as well. The 13th Amendment's more expansive than just slavery. Also, institutionalization of legal tools to basically put people in indentured servitude have also been banned with the 13th Amendment. And the 15th Amendment was a recognition that after the Civil War, although African Americans, they weren't even considered African Americans, that was 14th Amendment, freed slaves, in order to really be able to participate in society, had to have equal protection of the law and equal access to justice and equal access to public and later private institutions in order to be part of society, to be fundamentally fair. And so one of those things is voting. And so the 15th Amendment gives a prophylactic banning, if you will, of any kind of racial discrimination for men in voting. So you can't deny someone the right to vote that's a male based upon race, color, creed, or national origin. And this was considered fairly outrageous by the suffragette movement, the women's movement, because they fought so hard in the anti-slavery movement, the abolitionist movement, but they didn't get the right to vote then. And so the first piece of civil legislation, or civil rights legislation, that came out of the Civil War, 13th Amendment, and slavery. But the 14th Amendment, this is the great beauty, and this is going to be, it was designed for Africans that were freed after the end of Civil War with the 13th Amendment, but now there was a recognition there was all kinds of Jim Crow laws and other legal mechanisms in the South that really kept people of color in an inferior status, and there needed to be something to recognize it. And the 14th Amendment is where it's at. Later, other groups besides African Americans, any identifiable group, can come along. Gays, lesbians, people of age, people of certain religions. You name the classification of the identifiable group, and if that identifiable group has a historic degree of discrimination, they can use the 14th Amendment Equal Protection Clause to advocate that the laws need to be applied equally, or the government has to justify why it is discriminating against it. And that's the bottom line of the 14th Amendment. But it is the most beautiful amendment because it rectified great societal wrong that we had in our legal system. There's no question about it. So Section 1, well, of course I'm reading from the 13th Amendment. There's several sections in the 14th Amendment. And you can have a whole class just on the 14th Amendment. Some of you might go on and study more legal processes and classes in your coursework down the road, and you can take both undergraduate and law school or graduate school. You can take class just on the case law history of the 14th Amendment, how it's evolved over time. But the first one, all persons born or naturalized. This is how we determine whether someone's a citizen of the United States. Africans, we know, and you should know this case, Dred Scott. On the eve of the Civil War, Dred Scott was an African-American slave. He was taken to an area that was considered free soil in the country, somewhere in the northern part of the Midwest. And because that Dred Scott had lived there for a period of time, when he went back to his home state, which I believe was Missouri, he sued for his freedom, because that was sort of a traditional phenomenon that happened in some of the jurisdictions, that if you spent a period of time as an African slave in a free territory, you basically became empowered to be slave, to have the shackles of slavery removed from you. Dred Scott lost. The case went all the way to the Supreme Court, and one of our worst presidents in history. Every so often people ask me, who do you think was the best, who do you think was the worst? And President Buchanan is easy to vote for because he didn't do anything about the outbreak of secession in the South, but he also lobbied the Supreme Court directly to find that the Missouri Compromise and the Compromise of 1850 were unconstitutional, which was controlling how some states would become slaves, some would become free, to kind of keep a balance of power in this kind of contentiousness over the different political groups, anti-slavery, pro-slavery, or expansion of slavery. All of that was boiling within our nation for decades, And those compromises were keeping us at peace. But the Dred Scott decision kind of ruined the whole thing. And Buchanan lobbied the Supreme Court to do just that. So when Dred Scott came to the Supreme Court, a couple of the things came down in that ruling. One of them was that Dred Scott wasn't a citizen of the United States, and that the 14th Amendment overturns functionally. But the second thing was Dred Scott not being even a citizen because he was of an inferior race, according to the court. According to the court, it's one of the most hated decisions in our history because it is so repugnant to our sense of values as American citizens, I hope. But the second is that because African Americans were not only not people, they were property. And the Dred Scott decision said because the Fifth Amendment says you can't take away someone's property without due process of law or just compensation, people are free because of the Privileges and Immunity Clause basically to travel throughout the United States with their property. So if I own this cup of coffee, if I own this suit jacket, if I own that lamp behind me, if I own this phone, it's my property. Government can't take it away from me. And I'm free to do what? I'm free to travel with it. I'm free to take it where I want. And so therefore, it basically ended the Missouri Compromise, the Compromise of 1850, sometimes called the latter Missouri Compromise. In the Kansas-Nebraska Act, all those things basically go out the door. And it, in theory, opens up slavery to the entire continental United States because you could take your slave to Maine or Massachusetts or wherever, and the federal law couldn't ban it. Only the states could interior make a banning, and so that's why it probably wouldn't be able to come to New England, but you'd be able to go to these states where it wasn't resolved yet, whether or not it would be a free state or a slave state, and thereby tilt the balance of power. And it really rankled the abolitionist North, and it really buoyed the Southern interest of slavery's proponents into the eve of the Civil War. And then the debates between Douglas and Lincoln was actually for the Senate at the time, were debating over a lot of it, the Dred Scott decision. Could the federal government ever ban slavery in any location? Could the states in any location ban slavery? Or could they only ban it for their current inhabitants but not for visitors? All these questions were debated during that. Lincoln lost that Senate race to Stephen A. Douglas, but he beats him in the presidency. And as a result of that, Lincoln didn't get one Southern Electoral College vote, and the South declares, from a handful of states initially, but it grows, their succession from the Union. They're saying, well, you voluntarily joined the Union, now we're going to leave it. And nothing happened. Buchanan doesn't do anything about it. It takes a while before Lincoln actually becomes in office, and we know what happens. And that is that eventually Fort Sumner gets attacked in South Carolina. Lincoln finally has to start militarily. Then other states join the Confederacy. Northern states and some border states stay within the Union. And Lincoln initially wasn't for fleeing the slaves. He didn't think that was what the war was for. The war was for saving the Union. Over time, it does become a recognition that it is about ending slavery throughout the nation. So the 14th Amendment is to make sure the 13th Amendment has meaning, because if you remove slavery, you also have to remove the impediments from allowing a people to participate in society on some equal level. So the first one's recognizing citizenship. Anybody born in the United States or naturalized based upon the laws, and the laws have to be applied equally, are citizens of the United States. So African Americans now born, and many of them were born by that era, in the United States. Very little importation of new slaves was occurring at the time. They were born through slavery because there was laws in almost every state in the Union that had slavery, that a child born of a slave was a slave. And so all persons born or naturalized in the United States, subject jurisdiction thereof, are citizens of the United States and of the state wherein they reside. Not only defined national citizenship, but it defined state citizenship. It was considered a huge incursion in the states. The 14th Amendment strengthens the national central power of the government, and it weakens states' rights. There's no question about it. One of the more interesting things of the 14th Amendment, it didn't give Native Americans the right to be citizens. Isn't that kind of an irony? I mean, I'm not trying to laugh at an irony, but it's a dark irony, because they were deemed sovereign within their sovereign realms of the different kinds of reservation systems they lived on. They were considered sovereign nations, and therefore they weren't citizens. And that didn't change until 1920, I think it's in the book. Yeah, 1924, basically Native Americans were not granted U.S. citizenship until then. Just kind of shocking. So the 14th Amendment became the basis by which, in Article 1, about natural born citizenship. This is still a controversy to this day because we know there are people that immigrate to this country illegally, and some people call them, I think, a derogatory term, anchor babies. They have a baby here born on U.S. soil, and if a child is born on U.S. soil, they are deemed a citizen of the United States. And some people want to undo that. And in fact, most nations have laws banning such a practice. The United States doesn't. I don't think that's going to change. I think if anything's going to change is the nature in which we have more, I don't know, rigor in the way in which we allow people just simply to physically enter the country to avoid people from creating, basically giving immigrated status just by birth. Some people said that, oh no, if your parents came here illegally, children born here shouldn't have citizenship, but that's not the law. The law is clear, and there was some case law on it. It's a famous one where a Chinese couple came to the United States. They were not citizens of the United States. They came here legally, though, but they were not citizens. They gave birth to a child. Let's just call him John. John was born here in the United States. He goes back with his family back to visit China for a period of time. I don't know if he works or gets educated or something like that. Comes back to the United States, and somebody tried to deny him certain rights and privileges, saying you're not a United States citizen. He said, I was born here. And the Supreme Court held way back when, early 1800s, that being born in the United States gives you full citizenship as a citizen of the United States in the state where you choose to reside in. And no state can deny you that. So that's a big one. And the thing I want you to get out of the 14th Amendment more than anything else, because I do have to kind of rush through this video, although I'm looking at the time here. It says, the 14th Amendment became the basis of legal equality. And it doesn't mean we have to have equality in outcome, but equality in terms of the way in which the government would treat people and access to rights and protected rights. That's what it does. And it's amazing how to this day, when any group or any individual that believes they're being somehow treated differently than like-suited individuals, not based upon skill or talent or anything like that, we can discriminate on that. And we can actually discriminate on other factors, but certain immutable characteristics, race, color, creed, national origin, age, sexual orientation. Sexual orientation isn't quite clarified yet in the 14th Amendment, but sex between male and female has those kind of immutable characteristics that have long been a source of unequal treatment can be challenged through the 14th Amendment. And we know the most recent big one has been gays and lesbians, and they have been successful in basically shooting down DOMA, the Defense of Marriage Act, and now federal and state laws can't discriminate on people who are gay or lesbian who wish to marry. They have the entitlement to get married as long as they're competent of age, and they have the same rights and obligations as heterosexuals do. And the 14th Amendment, which was designed to basically create a more equal playing field for African Americans that were recently freed from slavery, have been used as a much more significant, powerful crowbar, if you will, for getting leverage to not equality, but equity and equality in access more than anything else. In no state, and this is a big one, no state shall make or enforce any law which shall abridge the privileges and immunity of citizens of the United States. This is called the incorporation doctrine. Basically, fundamental rights. So we don't know what they all are, and some of them aren't defined in the Constitution. Even the Ninth Amendment to the United States Constitution admits that there are certain things that we maintain as unalienable, basically fundamental principles like right to privacy, right to due process, right to fairness in our laws. Due process is the fundamental process by which laws will be adjudicated and applied. Substantive due process is the laws themselves have to be fundamentally fair. Both of those are embodied in the 14th Amendment, and they're used as a tool regularly by different advocacy groups to make sure there's equity in the way in which we treat our citizens. One of the interesting aspects of it when it comes up is, remember, the Bill of Rights were not applicable to the states, but through selective incorporation, not all in one fell swoop. Some of the Supreme Court, like Hugo Black, he wanted all of the Bill of Rights to be applicable to every state action. It's not true. In terms of what happened, the Supreme Court has selectively incorporated some of the, like freedom of speech, freedom of religion. I believe the Second Amendment now, although the book suggests it hasn't been yet through incorporation, but there was a case not that long ago, the Heller decision, did incorporate the Second Amendment to be applicable to the states. Certainly the Fourth Amendment, the Seventh Amendment hasn't. The Eighth Amendment hasn't in terms of bail, but it has in terms of cruel and unusual treatment. And so over time, for fundamental purposes, the 14th Amendment has basically said states can't deprive its citizens of these fundamental rights that the federal government nor can and hasn't been able to, because of the Bill of Rights, deny its citizens this fair treatment. And it's a big amendment. It's huge. It's monstrous, because for a long time, like some of you were into the Fourth Amendment, suppression of evidence, that only applied to the federal government for the longest time. States could do all kinds of inappropriate things in terms of how they searched and found evidence and use it against you at trial, and the evidentiary rules could be quite barbaric. And the federal government says, well, the Fourth Amendment doesn't apply to the states. Well, it started in the 1960s. They selectively incorporated it based upon what? The 14th Amendment to the United States Constitution. So that's selective incorporation. You should know the difference between procedural due process, fundamental fairness in the steps and procedures and application of law, and substantive due process, which is basically the content of the law must be fundamentally fair, both in terms of its direct language, it's got to be treating everyone equal, but also in terms of outcome, because you can have a law that looks objectively fair, but if it's designed to discriminate against one class of persons, it violates the substantive due process clause of the 14th Amendment. Think about it. I could have a law that says, I don't know. You have to be able to play all the scales on a piano before you become a member of the fire department in Springfield, Massachusetts. What the hell does that? It seems like it's fair, right? Everyone has the equal opportunity to play the piano. Who's more likely to be able to play the piano when you get a job? People maybe with a higher education, maybe economically discriminating against the poor who have never had access to piano lessons. So those kinds of things look objective on its surface, but might be inherently designed to rule out a certain economic class. And the other one I think of all the time is every so often you'll see a job, and it's it's an intellectual kind of job. You're going to be using your mind a job. It'll have something like must be able to bench press 300 pounds or something like that. Well, it's probably discriminating against women because they don't have the same upper body strength as men. But what if the job has nothing to do with upper body strength? Then it's what? It seems objective on its face, but substantively, it's discriminating against one group over another. Property, it gives all the different case law. Even Roe v. Wade comes out of this. Abortion, it was the first case. Roe v. Wade has not been overturned, but it's been changed. At one time, the case stood for that in the first trimester, women have a privacy interest, have an interest in their own reproductive rights in the first trimester, unfettered. The government can't ban a woman's right to abortion. In the second trimester, the state has more of an interest in regulating the methodology and the circumstances for the health of the mother in determining the nature of which abortion will take place. In the third trimester, when a fetus might become viable, then the state government might have some interest in banning abortions during periods of viability. That's been changed now. We don't go through this trimester analysis. Now it's it's the case. I'm trying to look for Planned Parenthood in 1992 Casey. Instead, states were allowed to regulate abortions if they did not place an undue burden on a woman's constitutional right to an abortion when the child is non-viable. So it's a similar analysis, but it's gotten away from the trimester measurements of it. That's still going to be challenged, and that's how you change the interpretation of whether or not the 14th Amendment has a privacy right interest to protect individuals in the states from an unwarranted intrusion into your fundamental rights, your inalienable rights, can change and can evolve over time. And there's some people believe that, if you push and push and push with putting some restrictions on abortion over time, the Supreme Court might interpret that the states do have an interest in that, and we as individuals don't necessarily have a privacy interest or a property interest that's protected by the 14th, and it changes over time. To deny any person within its jurisdiction equal protection of the laws. That's the big one. At one time, we know there was a case called Plessy versus Ferguson, came out of Louisiana. African Americans weren't allowed on the same boxcars as white people. They sued. In 1896, the Supreme Court says, whoa, it doesn't say anything about integration. It doesn't say anything about desegregation. What does it say? It says you have to have equal access to law, equal rights. And so as long as they're equal, it doesn't matter where they are, as long as you have the same kind of boxcars white people do. That was an 8-1 decision. Justice Harlan was the sole objection on that case and said that the Constitution really needs to be colorblind, and it's a real outrage that was allowed. And one of my favorite interesting things is, I don't know if you guys, you're not as old as me, most of you, but there's an actor named John Hurt, and he's pretty famous. And his great grandfather or grandfather, I'm not sure which, is Justice Harlan that dissented in Plessy versus Ferguson, which becomes the law in Brown versus the Board of Education. And he takes a great deal of pride in being related to Justice Harlan. And basically, the Plessy ruling said separate but equal was okay, and Justice John Marshall Harlan said the Constitution needs to be colorblind. And we know later that, and I don't know if I believe it was a unanimous decision, was the Brown versus the Board of Education, finally comes around and overturns it in a recognition in 1954 in Brown versus the Board of Education of Topeka, Kansas, that when you separate people, you do create usually physically inferior facilities, but you create inferiority just by the mere separation of people. There's just no question about it. And see how the 14th Amendment, through its evolution and application, does try to bring us more integration and more fairness. Doesn't require equal outcome, but it requires equality of access, and that's the key thing. But it becomes a bit of a challenge, because what happened after Brown versus Board of Education? Schools didn't integrate. Some of the kids, there was things called white flight. Kids would move out of the public schools and go to private schools because they didn't want to go to integrated schools. And then initially, oftentimes African Americans lived in predominantly African American neighborhoods, so their schools stayed African American pretty much in their neighborhoods. White kids stayed in white neighborhoods, and they went to white schools. And so to remedy the segregation problem through historic discriminatory patterns, the courts came up with the busing scheme. And those of you that lived through it like I did know that that wasn't necessarily the best solution to a clear problem, because when you do that, it sometimes created greater animosity between different peoples. And I was one of the kids. I had a school right down the end of my street. Supposed to go kindergarten through 6th grade in it. I ended up going to the 4th grade. But for 5th and 6th, I had to get bused to a different school for more racial integration. It seemed to me that school was had a very similar diversity than the previous one I went to, but I was unaware why I had to be bused. I don't know. I just thought I went from a really nice little school to a really big school that was really old. But anyways, I always remember that. And so separate but unequal, but we know some of the things that happened historically were deemed to be actually valid. Can the government, so here's the big question I'd like to posit to you before I kind of close this out. Can the government ever discriminate against different groups of people? Actually, no, it's constitutional, 14th Amendment of the United States Constitution. It can, but it has to have a rational basis for it. If it's discrimination based upon like-suited individuals, and we're going to discriminate against one group against another, the government has to have the ability to meet a certain test. If it's based upon race, color, creed, national origin, or religion, it bears what we call strict scrutiny. It has a heavy burden, and it must overcome to show the rational basis for it. And that's the basis they had to do in the Karematsu case. Our nation locked up 120,000 Japanese Americans, of which I think 2/3, close to 100,000, 90,000 of them were natural-born citizens. And did we treat them differently than non-Japanese Americans? Yeah, we did. We put them in internment camps during the course of World War II because of fear of their allegiance to the Japanese Empire. The Supreme Court held 6-3 that was justifiable. They met strict scrutiny. They met the compelling burden to avoid the undermining of the war effort, because they thought these people would be disloyal to the nation and commit subterfuge and sabotage and things like that without any proof whatsoever. That case has largely been deemed flawed, and today's court, I don't think, would have upheld that. But the point is there has been a history at times where a government has treated one race, one group differently in law, and it's tried to defend it. But does it have a heavy burden to do so? Yeah, they did it in Karematsu, and they were successful. I don't think they can do it again. But and when it comes to women, it's considered a slightly lower standard. It's not strict scrutiny. They have to show a compelling interest why they're discriminating against a certain sex, man or woman. It's usually women that are discriminated against. Then if it's things like age or sexual orientation, it's been a rational basis test. The government has to show it has a reason that's rational why they're discriminating. Well, why would they discriminate against, well, I'm not that old, but I'm saying, why can't an 80-year-old become a pilot and get a pilot's license to fly commercially? all their vision's tainted, their reflexes aren't probably as quick. And I think about my one of my cousins. I don't know if it's in this class, but I do have a class where there's a state trooper in it right now. One of my cousins was, I think it's 33 or something like that, was a cutoff, and he was on a waiting list, and he was trying to get an exemption for one more year because he didn't quite get into the last class. And he was talking, and he asked me, can they discriminate? He goes, well, with age, do they have a rational basis to discriminate at some point when it becomes to becoming a state police officer? I'd argue yes. I mean, come on, you lose a step, right? And you're gonna have to chase down people potentially. You got to be quick on your reflexes, and you got to be alert, and all these different things. And it depends upon whether it's rational or not. And so things like eyesight, sometimes we discriminate against people with lesser eyesight than better, but is it corrected with contacts or other things that make it an unduly burdensome against one group or another? And so that's the kind of test we have. Gender discrimination. In fact, Ruth Bader Ginsburg, who died not that long ago, she got her chops, if you will, her reputation as an advocate for women's rights. And she's the one that actually elevated the test to make it much more burdensome for government to show why discrimination against women should ever be allowed in employment and other areas. And then she ultimately got into the Supreme Court, and she fought for. So did Thurgood Marshall. He was the one that was the arguer, or the proponent, the attorney that proposed that separate but equal is inherently flawed in Brown versus Board of Education. He went on to become a member of the Supreme Court. But I think all of us, I mean, if you've never been discriminated against, or you know someone has, you can imagine what's the tool to at least be able to address it in an open forum, to bring it to the fore to see if it's right. Now we have something sometimes called reverse discrimination. I don't like that term. It's not reverse, it's just discrimination, where they try to put in certain things to remedy long histories of past discrimination by creating certain things like affirmative action, like we want to hire so many people of color, of certain race or certain ethnicity, to make up for past wrongs and to create a more diverse society's success. And the argument there is, well, if I've got a higher grade on the test, if I've got better skills, it shouldn't have anything to do with race going forward. And those are the kinds of debates that we still have going on with the court right now. Most recently, the affirmative action cases have been shot down. And I don't want to call it because of reverse discrimination, but because it is a form of discrimination based upon race, color, creed, or national origin. And the government couldn't show the necessity to do so because it created racial disparities in its outcome. It was directly discriminatory. Reapportion it. We know you can't reapportion voting areas solely based upon race, even if it's beneficial. Like say, we really want to create, we really want a seat where, we have strong African representation. So we're going to create a map, a congressional map where there's a large population of African residents, African American residents, and therefore they'll be likely to have a voice in Congress that they choose that would be unique. And it seems like it's got a good goal, but you can't do it based upon that. You can't do it based upon that. So the Supreme Court ruled in a series of cases that absent a compelling interest, race cannot be a primary factor in the redrawing of boundaries of legislative districts, even if it has good intent behind it. Can't do it. Section 2, we know about that ends basically the 3/5 clause. We know it didn't give women the right to vote at all. It was only men. The 15th Amendment, the 14th Amendment gives it teeth. And here's the big one. Article 5, in my opinion. Congress shall have the power to enforce through appropriate legislation the provisions of this article. We know that's important because when the Civil Rights Act of 1964 comes on, it tries to end discrimination in private spheres like employment, housing, and that was 2 years later, but all of these kinds of acts come down from the federal government to end discrimination in certain publicly subsidized areas, or those that are impacted by commerce. And a lot of people say, well, where do you get the power to do it? 14th Amendment Clause 5 basically gives the Congress the power to implement basically the equal protection clauses of the 14th Amendment through legislation. Really interferes in state rights, grows the national power. I think rightly so, because if the states were allowed to do it, many states wouldn't do it. I know I went over that quick. I put up much better videos than I have, but no one wants to watch me for 35 minutes for crying out loud. But I feel like I have to talk about this stuff. Give us a sense of presence, like I'm somewhere in the classroom. So these are the Civil Rights Amendments, the one that's most important. I mean, somebody can say, well, Jim, the 13th Amendment's the most important, and that is slavery. Yeah, but there's a different kind of slavery if there's not equal protection of the law and fundamental fairness in the way the laws are written, and that's the 14th Amendment. And the same with, well, the 15th Amendment gives African Americans, males, the right to vote, and states can't discriminate against that. That's true, because without the power to vote, without the power to participate in civic life, but it's the 14th Amendment that really embodies the meanings behind the 13th and the 15th and the goals. I think of them all as one in many respects. Maybe I shouldn't, but those are the amendments that really clean up the errors of our discriminatory past in law more than anything else, the 14th Amendment. I'm going to do something else on the other amendments to kind of tie up the course because we're running out of time. But the 14th Amendment, really spend some time on. Read those articles I posted. Look at the videos, which are much more entertaining to me than from YouTube that I put up as well. And otherwise, feel free and encouraged to ask questions.